Oh, okay.
Yeah.
Great. Yeah. So our advocacy mostly focuses on interventions. But as I mentioned, we are not an organization of persons with disability, but an organization, a human rights organization that advocates for the rights of every person, including persons with disabilities. So within the commission, we have several, two main projects on disability. One is global, which we are implementing in Africa, Latin America, and in Asia. And then another project which is directly related to the conversations we are having in this conference, which focuses on the Africa Disability Protocol. So advocating for its ratification and full implementation. So our advocacy on disability involves mainly working with organizations of persons with disabilities, providing legal and technical support on the basis of requests by the organization of persons with disabilities. And as far as the protocol is concerned, we joined the campaign towards ratification or coming in because of the African Disability Protocol, which is quite exciting. Some of the highlights of the activities that we'll be taking soon or that are coming up and this touches on a question that was asked yesterday about guidelines or general comments on the African Disability Protocol. So it recently came into force. The African Commission, which is the body which has the mandate to interpret the protocol, has not yet begun developing normative frameworks or standards on the protocol. So that's one of the advocacy angles that we are undertaking as the as the International Commission of Jurists. The first main activity in this regard is, or maybe by show of hands before I proceed, how many of us know of the ordinary sessions that the African Commission has and that takes every 2 years? Or how many of us have interacted or participated in the African Commission's ordinary sessions?
Only what?
We only have one hand.
2 hands.
3 hands.
4 hands.
Since the hands are still going up. So in our research or engagement with different entities, we've realized that, and maybe just to mention, I'm a person with disability myself, so the advocacy work that we are leading in this regard, or that I'm doing in this regard, is also based on personal interest and self-advocacy. But we have realized that organizations of persons with disabilities or persons with disabilities themselves hardly engage with the regional mechanism as opposed to the international mechanism, which is the CRPD. Now that the CRPD, the African Disability, has come into force, there are some mandates which are provided for under the CRPD, under the African Disability Protocol, which apply to organizations of persons with disabilities and civil society, to states, but also importantly to the African Commission on Human and People's Rights. So as far as the African Commission on Human and People's Rights is concerned, the mandate to interpret the provisions of the protocol falls squarely upon it. But it is upon organizations of persons with disabilities to determine or to give guidance on which areas we would require more clarification on, as far as the rights of persons with disabilities under the protocol are provided for. So in the upcoming session, and I'm happy to speak on this maybe during breaks, which is taking place in October, we are organizing a side event on the 18th of October, which will bring together the commission, the commissioners who sit within the commission, but also representative of member states who will be there to chart a way forward with respect to the mandates of the various entities. And as far as organizations of persons with disabilities are concerned, one of the main mandates is to ensure that those states which have not ratified or expressed interest to be bound by the protocol also do so, right? So that's an opportunity to do so, and that's one of the activities that we'll be doing in October. And then the global project focuses on access to justice. So I mentioned that our advocacy is mainly based on legal interventions through research, through advocacy, capacity building, and through litigation. So when I say capacity building, I mean building the capacity of persons with disabilities to enforce their rights, but also building the capacity of the justice sector to understand the rights of persons with disabilities, or to ensure that persons with disabilities are properly accommodated within the justice sector. And in this regard, we have an upcoming forum which we can speak about again during breaks, a regional event on access to justice which brings together persons with disabilities, the justice sector, but also people who focus on access to justice in their line of work. So next slide. So the focus of our conversation today is on contemporary issues under the African Disability Protocol. And some of the areas which I was asked to speak about are SRHR, sexual and reproductive rights, and also technology. Although I will focus on those which time might allow to focus on, but in this regard mostly sexual and reproductive health rights, and also technology under the protocol. So maybe before we begin, if we speak of the right to sexual and reproductive rights, or generally sexual and reproductive rights, what comes to mind? Or if I ask you, what do you consider to be among a sexual and reproductive rights of an individual, whether with a disability or without a disability? Can I get some volunteers?
Question?
Huh?
The question.
So, sexual and reproductive rights. What are some of the, when we speak of sexual and reproductive rights, which rights are we talking of? Or what comes to mind when we hear sexual and reproductive rights? Rights to health. Very fundamental.
Sexual rights.
Huh?
Sexual rights.
Sexual rights. What do you mean by sexual rights?
It's the right to choose when, where, when, how.
I think for me is the right to choose who you engage, and the right to choose what to do with your body.
Exactly. The right, that's a critical component.
Right.
Yes.
Reproductive rights.
Such as
When To have a baby.
Yes.
You may want to have a baby at all.
Yes. Whether to have a baby, when to have a baby, the spacing of the babies, right? Yes, that's very critical.
And who to have babies.
Yeah.
In addition, the right to protection or self-protection from STIs, HIV, all of that, and access to health care.
Yeah. Equal access to health. Yes. So all those actually fall within the scope of sexually and reproductive rights. Yes. Okay.
I would say educate healthcare for women when giving birth, ensuring that the baby is healthy and the woman doesn't die during childbirth.
Great. Yeah. I was told there are two more hands, so there's one more.
I think right to privacy.
Privacy.
Yeah.
But that's very general, so
For instance,
I would relate it to.
Okay, you're going to the hospital or to get an HIV test, you have the right to privacy. Nobody has to know about your status.
Yeah.
For me, I think it's the right to choose whether you should have a baby and if you don't want access to abortion.
Access to abortion. Yeah. That's all they have, right? Okay. Great. Family planning, that has been also mentioned. So now, slide 7. So all the examples that have been given by colleagues fit within the auspices of sexual and reproductive health rights. And it is critical for us to understand how then these rights apply for persons with disabilities. And I hope we were all paying attention to the examples that were being issued. For us to speak on how the Africa Disability Protocol, or generally legal frameworks, protect the rights of persons with disabilities with respect to SRHR, it is also important for us to understand some of the barriers which persons with disabilities, especially women and girls with disabilities, face in this regard. So I have had 3 keywords when we were sharing the example: bodily autonomy, choice on whom to have sex with, when and how, whether to get children, and the spacing in that regard. So that's on choice as well. And also the right to access services with respect to reproductive health and rights, including the right to abortion. Then the next question would be, do these rights, in your experiences or in the states from which you operate, do these rights apply equally for persons with disabilities, especially for persons with intellectual disabilities and persons with psychosocial disabilities? So there are some barriers which have been identified with respect to access to SRHR for persons with disabilities. And to mention some of those barriers, We will use those which have been identified by the committee, CMRPD, the Committee on the Rights of Persons with Disabilities. And the reason why I'm relying on this is because they are not just it's not just based on research, but the committee gives, it's based on concluding observations that the committee has issued. So for the Committee on the Rights of Persons with Disabilities to issue concluding observations, it means that states, including persons with disabilities, have made reports about the situation of human rights in the specific countries, including with respect to SRHR. So those which have come up often, the issue is that persons with disabilities in most African countries are not are not guaranteed with the right to bodily autonomy, or they cannot exercise the choices that we have spoken about today. An example, a case in point, is there are instances where persons with psychosocial disabilities, especially women and girls, are subjected to forced sterilization because there's a societal belief that persons with disabilities should not get children. Or they will get children, but they will not be able to take advantage or take care of those children. Or they will get children, but those children will also be children with disabilities. Other examples are with respect to accessibility, for instance, with the providers, service providers or public institutions, health institutions that provide SRHR services, such as maternity services. How accessible is the infrastructure for persons with disabilities? Reports in this regard also show that at some point, or in some instances, persons with disabilities, for instance, persons with physical disabilities, have been forced to give birth from the floor of a hospital because the bedding is too high, the bed is too high and cannot be adjusted, or even in some cases, they are not provided with support with respect to accessing. So I don't have experience in this. But in forums I have attended, someone gave an example of they were slapped and told, why aren't you getting onto the bed? So that is with respect to persons with psychosocial and intellectual disability, but is not limited to them. Another example, so I'm just putting some flesh and blood into these instances that have been identified by the committee in interactions with states. When we go to a hospital or a public health institution, my experience, and also I think it's the same case in most countries here, is that you wait in a lobby or a reception area, and then when it is your turn, what happens? They call your name, right? Sometimes they just shout your name, Wilson, or Wilson Mashari, go to this and this doctor. Now imagine a patient or someone is accessing the service and they are deaf. How many public health institutions or hospitals actually use sign language as well? Yeah. So the reason I'm asking about this is persons who are deaf have also shared their experiences, and they involve one experience that was recently shared. And when I say recently, it's because there's a study that we are currently undertaking as the ICJ, which involves some interviews with some key informants. A participant in that regard mentioned that they were once in a queue and they wanted to get access to family planning. Her name was called out, but she didn't know. She relied on lip reading also, but unfortunately the person who was calling the names out was not even in the same room as the waiting area. So she only realized that she wouldn't access the service when everyone else who she was waiting with was left. They went got the services, or saw a specialist and left. And then ultimately the specialist also left. And then when they explained to the service provider using a pen and paper, like I'm still waiting for this service, the service provider said, I called your name several times. So those are some of the experiences that persons with disabilities have with respect to accessing health services generally. And it is important for us to understand that SRHR, as far as international human rights instruments are concerned, they are mostly provided for under the right to health. In other cases, slide 9. So those are some of the barriers that persons with disabilities face within the society itself because of societal norms. And remember yesterday in Ignatius' presentation, we were informed of the fact that persons with disabilities are deemed to be incapable until they have to prove that they are capable in whichever area of life. So in other instances, there are actually laws or legal frameworks which limit sexual and reproductive rights of persons with disabilities. And in some instances, even criminalizing the choices of persons with disabilities. For instance, the right to choose a sexual partner, the right to access or to have pleasurable sex with a partner of choice. So there are some examples which are shared. I hope that's what we are projecting on. Some examples of laws in several countries, some of which are represented in this room, how they limit or restrict the right of persons with disabilities to make these choices. And this is closely related to the right to legal capacity, legal agency. So maybe just an example. In Kenya, the penal code recognizes as a crime to have carnal knowledge with a person with intellectual or a person with psychosocial disabilities. And I say that because I'm avoiding to use the terms which are in the law itself. So they say carnal knowledge with imbeciles or idiots. But yesterday we had a conversation about the terminology that is preferred by most of our laws. So one question that I would have to you, and it has been subject to debate, what would you think of that approach? Would you find it to be consistent with the human rights model of disability? Or should having sexual relations with a person with psychosocial disability or a person with intellectual disability be criminalized if it is based on the choice of that person? Or maybe a more interesting question, can a person with psychosocial disability consent to sexual relations?
Yes.
I'd like to hear some of the respondents tell us why.
My response would be actually a question, why not?
Why not? So the response to the question is why not? Why should a person with disability not have sexual relations with intellectual and psychosocial disabilities? The response to that question, and it's not my response, it's according to the laws of several countries, some of which are displayed on the screen, including Kenya, is because the person cannot consent, or the person does not have the capacity to consent, which is a wrong approach. So in some instances, beyond just the societal norms, the laws of our countries already take away the capacity of persons with disabilities to consent or to enjoy sexual and reproductive rights. And that is why it is actually important to have a legal framework in place that recognize that persons with disabilities have SRHR, sexual and reproductive rights, like any other person without a disability. So initially, when we were beginning the conversation, I mentioned that the right to the sexual and reproductive rights are recognized under the right to health. So with respect to the African Disability Protocol, the right to health is provided for under Article 17, which I would like to request one of the participants to read for us. Article 17 of the African Disability Protocol.
Right to health. One right to health.
Yes.
Well, so let me read the Article 17. Article 17, point 1, every person with a disability has the right to the highest attainable standard of health. And 2, state parties shall take appropriate and effective measures to ensure persons with disabilities have, on an equal basis with others, access to health services, including sexual and reproductive health, such as by providing persons with disabilities with the same range, quality, and standard of free or affordable health care and programs as provided to other persons. B, providing those health services needed by persons with disabilities specifically because of their disabilities, or health services designed to minimize or prevent further disability, the provision of medicines, including pain relieving drugs. C, by prohibiting discrimination against persons with disabilities by providers of health services or providers of insurance. D, by ensuring that all health services are provided on the basis of free, prior, and informed consent. E, providing persons with disabilities with health care in the community. F, ensuring that healthcare services are provided using accessible formats and that communication between service providers and persons with disabilities is effective. G, ensuring that persons with disabilities are provided with support in making health decisions when needed. And H, ensuring that health campaigns include disability-specific needs, but in a manner which does not stigmatize persons with disabilities, and designing services to minimize and prevent further disability. And finally, ensuring that the training of healthcare providers takes account of the disability-specific needs and rights of persons with disabilities, and ensuring that formal and informal health services do not violate the right of persons with disabilities.
Thank you very much, sir. So one thing that we would realize in that regard is and we discussed this extensively yesterday, that the aim of the African Disability Protocol is to supplement or complement the provisions under the CRPD. And the rights provided under the right to health are written in almost similar terms as those on the CRPD. But there are certain additions under the African Disability Protocol which actually provide more protection on sexual and reproductive rights of persons with disabilities. Not to say that they are not recognized under the CRPD, they are, but in most cases they are found within the normative framework by the Committee on the Rights of Persons with Disabilities in its general comments. So there are several. There's a list, a number of these that we can list. Yesterday we learned that the protocol includes additional rights for the rights of the youth with disabilities, which is not on the CRPD directly, and also the rights of older persons with disabilities. So one key provision under the protocol is that it promotes or it establishes an obligation upon the state to promote sexual and reproductive health education for youth with disabilities. The reason why this is important is we would basically or generally imply that from the provisions of the CRPD, but it has not been previously codified under a binding law like has been on the African Disability Protocol. So the mandate of the state to promote SRHR education amongst persons with disabilities is a very critical provision and should be recognized as one of the additions that the African Disability Protocol brings in this regard as far as SRHR rights are concerned. In addition to that, as far as the youth with disabilities are concerned, beyond the Convention on the Rights of Persons with Disabilities, the right to promote SRR education to the youth has not been codified in any other international law. At least as far as researchers in the area of disability rights are concerned. Yeah. So that's one of the key elements which we would recognize in this regard. And I will proceed to the next slide. So we proceed to slide 16 on access to technology. But maybe before I proceed in that regard, my question would be to you participants. We have seen that the African Disability Protocol, of course, not all state parties represented here have ratified the protocol, but the specific laws in the context we come from already codify the denial or restriction of the sexual and reproductive rights of persons with disabilities. So, as far as this is concerned, Do you think that this, the provisions of the protocol has value for states which have ratified the protocol, or even those which have not but will be ratifying it? And then how would this apply in our specific countries? In the event that there is this provision under the African Disability Protocol and generally the CRPD, recognizing the sexual and reproductive rights of persons with disabilities, but in our specific states, having provisions that actually take away the SRHR rights of persons with disabilities, which ones would take precedence in our specific context? Can I get any responses?
Yes.
I think one that should take precedent is that one of educating youth with disabilities as well as disabled people in general vis-a-vis their sexual reproductive rights. And secondly, one should look at the services that are provided by primarily government institutions, be it hospitals, as far as people with disabilities are concerned and their rights vis-a-vis sexual reproductive rights.
Thank you for that response. Which country?
South Africa.
South Africa, yes. So the question that I'd also, something that I'd also like to hear from you is this provision, and you said they are valuable with respect to the rights of persons with disabilities. But then we are in a situation where the local laws or the laws that inform sexual and reproductive rights in South Africa are not in the same terms as this on the CRPD or the African Disability Protocol. So in South Africa, for instance, which one would take precedence? Or how can we cure also that gap where there is a difference between the provisions in the local laws and that on the international laws?
National laws.
Anyone like to attempt?
Yes. Two things. In law, there is this principle of exhaustion of legal remedies locally at local level. So, to the extent possible, one needs to exhaust all legal measures available at domestic level. And then there is also the principle of subsidiarity. International law is always subsidiary to local domestic legislations. So we need to keep that in mind, and precedence should be given to domestic laws.
Thank you very much. So it means that.
What's in this one?
Okay.
I think so. So it's really on what's in effect and what should happen, right? In terms of the law itself, let's say in South Africa, international law that directly applies, it has to be domesticated first. So which means that the South African state, once they've ratified the ADP, they have the duty to change their domestic laws so that they are in line. But until they do so, the local law is the one that applies.
Thank you.
There's one here.
Yeah, I'm covered by the lady next to me because I wanted to say that the disjunction comes when there is no domestication for the application or the effect of the international protocols. And so I think that's key in the advocacy for the ratification, that should be a two-stream approach because it also takes years to domesticate or even to find. I mean, other countries are still researching how to develop the local law emanating from the UNCRPD. Thanks.
Thank you.
Good morning. In Namibia, there's an ongoing debate regarding the dualist and the monist approach of international and regional instruments. In our constitution, in Article 144, it states that any legal instrument ratified by Namibia is binding upon the country. It forms part of our domestic law. But similar to the points from SA, although it forms part of our domestic law, it's the application that becomes problematic. It's currently a legal debate that's ongoing because by virtue of the constitutions of supreme law, if it becomes part of the domestic law, it should be equivalent to our statutes as well. But however, in practice and in the judiciary, we've seen that these statutes do get precedence in comparison, in contrast to international and regional instruments.
So I think what we get from this and where I was, what I was trying to get to. So there's, as you said, that whole debate, and not only in Namibia actually, it's most countries in Africa and generally in the world, where there's a challenge or a difficulty in identifying the hierarchy between the different laws, the local laws and the international laws. But we also find ourselves in a position where, as persons with disabilities, we have participated or advocated for an instrument that recognizes our will, interest, preference, and our choices or our rights at a global level and at an international, at a global level and at a regional level as well. The mantra that is often used when developing this instrument is nothing for us without us. And now when you summarize it, it's simply nothing without us. So we have these great instruments, but as far as we have seen on that table that I was projecting previously, we still have our national legal frameworks which restrict the rights of persons with disabilities on SRHR, but also generally. Then the next question then would be, how would this apply or would it work for us as persons with disabilities? One of the approaches has been mentioned by our colleague Nacho, that one of the avenues that is available to us as advocates on the rights of persons with disabilities is to actually challenge these laws. The mandate to review national laws forms upon our different legislature, the bodies that legislate our laws. But the question is, are they aware of these instruments on the one hand, but secondly, on the rights of persons with disabilities from our own perspective? There's a question that I asked earlier. Can a person with intellectual disability or a person with psychosocial disability consent to having sexual relations with someone else? And the question we received is, why not? Is that the question that we would receive from a legislature who's not focusing on disability rights? What would they say?
They would say no.
They would say they cannot consent, and we even have laws that protect them. Right? And then also that means is when a person with psychosocial disability wants to exercise their right, the person they are exercising the right is may be subjected to criminal, may be found to be criminally liable. So as persons with disabilities, we need to initiate conversation on this, reviewing these laws. And one of the ways of doing that is whether challenging those laws in court all the way up to the apex level, in court, or undertaking advocacy and building the capacity of the legislature, and also ratifying or advocating for domestication of the African Disability Protocol, at least in countries which recognize international law as part of their laws after they have been ratified. So for instance, Kenya, that is the position. It's very similar to Namibia. And for us, the courts have said international law actually forms part of Kenyan law, which is provided for under the constitution. But as far as we still have these existing national laws, then the rights of persons with disabilities may not be realized. Moving to the next provision or contemporary issue, which is on technology. The first question I would have is, would you consider, or in your view, is accessibility or the obligation to ensure accessibility of public services and so on and so forth a right? Is accessibility an individual right? Would you consider accessibility as an individual right? Yesterday we were told the difference between reasonable accommodation, which is individualized, and accessibility generally. Any views? And as we receive the views, I'd like one of us to open Article 15 of the African Disability Protocol, and someone else Article 9 of the Convention on the Rights of Persons with Disabilities.
Can I get a mic? I'll try.
Is the question if accessibility is a standalone right?
Yes, is accessibility. Do you consider accessibility as a standalone individual right?
An individual right. It depends on access to what. Because the right to education is, let me use the Namibian context that I think this is very interesting because when we were doing our national consultations on the Persons with Disability Bill, a lot of the responses from government were that why are you raising education and healthcare and as new rights, because these rights already exist in the Constitution. And we obviously raised the issue with regard to accessibility. My point is I don't have an answer, but I want to contribute to the conversation. Is that the debate was in essence whether the person with disability, if accessibility is denied, then accessibility is either an enabler to a substantive right or it's a limitation to a substantive right to pre-existing rights. But there's a new right now in Namibia with an act, which is the Access to Information Act. And that created a right in itself, that access to information is a right in itself. And so that's why I was saying that, in my view, it depends on the substantive right, but accessibility can either be a limitation or it can be an enabler to a substantive right.
So thank you for that. We'll come back to that. We have a volunteer to read for us the Article 9 of the CRPD, Article 9.1. That's the first part.
Article 9 of the CRPD to enable persons with disability to live independently and participate fully in all aspects of life. State parties shall take appropriate measures to ensure to persons with disabilities access on an equal basis with others to the physical environment, to transportation, to information and communication, include information and communication technologies and systems, and to other facilities and services open or provided to the public, both in urban and in rural areas. Though these measures shall include the identification and elimination of obstacles and barriers to accessibility and apply to inter area.
Okay, we can leave it at that. But in few words, what I've heard from that is what the CRPD, the Article 9 of the CRPD says is state parties shall take measures to ensure accessibility. Are we aligned? Is that what we also heard? Yeah? Okay, can we have someone read to us the first section of the first part of Article 15 of the protocol?
Article 15, accessibility. Every person with a disability has the right to barrier-free access to the physical environment, transportation, information, including communication technologies and systems, and other facilities and services open or provided to the public.
So what are the first, could you read the first few words for us? Every person with a disability has the right to barrier-free access. Are those the similar terms that are used under the CRPD? Okay. So I'll give some context why I'm asking this, and it means that also your guidance will be helpful. Yesterday I mentioned that in Kenya we have ongoing litigation on access to banking, where financial institutions deny or restrict the rights of persons with disabilities or specific types of disability to access their financial services. So in some instances, they say you cannot open an account unless you donate a power of attorney to have someone operate it for you. I recently had a similar experience. In other instances, they say if you're a person who's blind, you cannot have an ATM card or a debit card. If you're a person with intellectual or a person with psychosocial disabilities, you need someone else to operate the account on your behalf. So the litigation is on the basis of discrimination, but we got a question that we needed to figure out before making submissions before the court. Because the way the CRPD puts it is that the state has an obligation to, among other things, develop minimum standards on accessibility. And in this case, the respondent is a private entity. So as far as the CRPD is concerned, the easiest approach for us was to say the state, through the regulator, has not fulfilled its mandate to ensure accessibility through standardizing the practices of financial institutions. But the Africa Disability Protocol says that persons with disabilities have a right to barrier-free access, including to financial services. And the interesting thing is, as we said, Kenya is a monist state, or that's where the debate is aiming towards, and confirmations by the court. So when it ratifies a law, it automatically forms part of Kenyan law. So Kenya has ratified the African Disability Protocol and is therefore part of its local law. So the question is, as a disability rights advocate, would you claim an individual right to access? And my response to that is, on the basis of the African Disability Protocol, then yes. Generally, when you look at the distinction between access, the distinction between individual rights to accessibility and the right to accessibility generally, the individual rights falls within the provision of reasonable accommodation, which we understand as making modifications that are individualized, so that are based on a specific requirement or request or disability of an individual with a disability. But as far as accessibility is concerned, it creates an obligation to ensure universal design, that all products and services are designed in a manner that they can be accessed by everyone, regardless of their type of disability, for instance. So that's a key deviation from the way we understand accessibility under the CRPD. But again, it provides a better layer of protection for the rights of persons with disabilities. The next item that I'd like to touch on is with respect to access to information, which is directly related to technology, which we are currently speaking about. A minute. Slide 22. So there is another distinction between the way the CRPD approaches, as I conclude, approaches the right to access to information, including information, communication, and technology, and the way the African Disability Protocol. And for this one, I'll wait for you to tell me, although I suspect that it's already on the screen, which one provides a better layer of protection. So access to information under Article 21 of the CRPD requires or states that a state party should urge private entities which provide public services to ensure accessibility for persons with disabilities. And it also proceeds and says state parties should encourage private entities to ensure accessibility of their products and services to persons with disabilities. On the other hand, the provisions under the African Disability Protocol, it uses the term require, that private entities are also required to ensure that their products and services, including ICTs, are accessible by all or for all persons with disabilities. For me, the way I understand it is that the protection under the African Disability Protocol gives a better layer of protection, because going back to the case where we are speaking about access to financial services, when we are making submissions, then we will be using the term encourage, like private entities should be encouraged. But under the Africa Disability Protocol, private entities such as banks are required to ensure accessibility. We go back to a debate similar to something we had yesterday. Do the use of specific terms have an impact on the protection of on human rights? For instance, the rights of persons with disabilities. Or from your point of view, is there a difference between using the term required and encouraged? There is? And which one would then provide a better layer of protection? Required. So, the African Disability Protocol is very critical in this regard because it already establishes a mandate that I can go to a public entity or private entity and claim my rights to access their services. But if they would only be encouraged, then they have an option to opt out or say, we are not yet at that level, but we will consider it. Same conversation as progressive realization in economic, social, and cultural rights.
Wilson, address my hand on the before you go, I just want to go back to the ceremony and its provision and protection around private spaces.
So my question is whether we should read an article in isolation when we're reading about the different provisions of both the protocol and the CRPD, or we should read the articles, the substantive rights articles in line with the provisions under the general obligation. And I refer to Article 4 of the CRPD, 4.1e on the general obligations that states must take to ensure that all human rights and fundamental freedoms of persons with disabilities are implemented without any form of discrimination. So E says that to this end, state parties undertake to take all appropriate measures to eliminate discrimination on the basis of disability by any person, organization, or private enterprise. And then the second question I would have is whether we should read the articles and also look at the jurisprudence that has been developed by the CRPD committee, whether through its concluding observations or general comments, and whether that helps in terms of expanding and elaborating what the committee meant, what the instrument, that is the CRPD, means by either urge, require. So I agree that the words means they could either prohibit, delay or misinterpretation of it, but what about the jurisprudence that we've seen coming out of the committee? Is it providing clarity under that? And should we read articles in line with other provisions of the instrument and not in isolation? Thank you.
Thank you for those great questions. And indeed, the jurisprudence, for instance, on the CRPD, already informs how the rights under the CRPD are informed. And that's an advantage so far that the African Disability Protocol does not have. And one of the advantages also that the Disability Protocol has is that the African Disability Protocol is during the development or the drafting of the protocol, it also benefited from some of the normative frameworks or jurisprudence that has already been established under the CRPD. The challenge in this regard, and why I was focusing on that, is we are putting ourselves in, or I was putting myself and you also in a position where you are before a judicial authority claiming a right or that a right has been violated. The challenge often is that the law, in Swahili we say, sheria ni msumeno. How would we say that in English? The law is an act.
I have to do direct translation, meaning that the law, I don't know, it's hard to translate.
It's like it cuts in front end. So they say it's like the law is a sword. It can be used in your favor and can also be used against you. Right?
Two-edged sword.
Yeah.
Double-edged sword.
Double-edged sword.
Both ways. It's a double-edged sword, exactly.
That's it.
Yes, thank you very much for that. So the law is a double-edged sword, and it can be used to support your case, but also the respondent or the other party can use it to justify their actions. So the reason I'm saying this is, allow me to rely to speak on progressive realization and economic, social, and cultural rights. So economic, social, and cultural rights, in most cases, the way they are framed, they say the state should progressively realize the right to employment for persons with disabilities. Usually when you claim that right, or you say that the state has failed in its duty to ensure that, then the state often say that we are progressively realizing this right, even though it has been 10 years and we've only done 1% instead of 5% if that is the quota. So the reason I'm saying that this provides a better layer of protection is if you're before a judicial authority now, beyond relying on the jurisprudence from the Committee on the Rights of Persons with Disability, the Africa Disability Protocol already shows that it's an obligation that a private entity has. And therefore, it cannot use the term, we will review our processes moving forward to justify their actions when they did not recognize that. I don't know whether that responds to the question. Have I responded to it? But now, as I conclude, just two more things to mention. As far as access to technology is concerned, there's an instrument referred to as the Marrakesh Treaty. It's an international instrument that promotes access to published works for persons who are blind, visually impaired, or other kind, or in other terms, print disabled, for people who have print disabilities. The requirements under the Marrakesh Treaty is for states to review their copyright laws to ensure that published materials can be reviewed or can be converted to accessible formats to ensure that persons who are blind or visually impaired or have print disabilities can access them. However, there are several states which have not ratified the Marrakesh Treaty, and there are states which have ratified the Marrakesh Treaty but have not yet reviewed their copyright laws. So one key component that the Africa Disability Protocol has included, and its right to access to information, is that the state has a mandate to ensure that persons with visual disabilities, persons who are blind or otherwise print disabled, have the right to access published works. In my assessment of that provision, it means that it is, I'm not downplaying the importance of ratifying the Marrakesh Treaty and actually enforcing it. But in a state or in a situation where the state has not ratified the Marrakesh Treaty, then one could use the African Disability Protocol to enforce the right to access published rights. And I think that that also informed the framing of that specific protocol, specific provision. But in this regard, it's also important that and it was mentioned yesterday, that both the Convention on the Rights of Persons with Disabilities and the African Disability Protocol have safeguard clauses or safeguard provisions. So this should not be seen as only an act of doing a comparison between the African Disability Protocol and the Convention on the Rights of Persons with Disabilities. The beauty of having both these instruments is that they both state that the provisions, the human rights of persons with disabilities should be interpreted in a manner that safeguards or best safeguards and protects the rights of persons with disabilities. So one can use the lack or the failure of one instrument to recognize a specific right should not be used to justify the denial of that right. So if you read Article 4.4 of the Convention on the Rights of Persons with Disabilities and Article 36 of the African Disability Protocol, you will see that safeguard right, which means that as persons with disabilities or persons with disabilities should not be denied rights in justification that a state has not ratified one or the other instrument, or chooses or prefers to implement one or the other instrument. I think I'll stop at that and invite any questions in that regard.
There's about 3 questions in the room, so she'll take one.
Yes, my question is on sexual. Yeah, my question is on sexual reproductive rights. The provision of services that persons with disabilities might require. So my question is, what's your opinion on IVF treatment for those who might require it as people with disabilities, bearing in mind that should it be a state obligation, or bearing in mind that it's a very expensive process? And in some countries, for instance, in America right now, Donald Trump was campaigning for free IVF treatment.
Thank you. Mine is not a question, it's just two points. Number one is denial of rights under the guise of protecting persons with disabilities. Just reminds me of
So there's just be one signature.
the road to somewhere is paved with good intentions, right? So the road to heaven is paved with good intentions. If we mean that we protect the rights of certain individuals without actually talking to them and adhering to their rights with their preferences, then it's not protection at all at the end of the day. The other one is, I wanted to reiterate some Article 2 of the Safeguard Clause under Article 36, the African Disability Protocol, which I remember during the validation, and I was just talking to Thomas about that. When the protocol was validated at the draft stage in Addis Ababa in 2016, we were there, and this provision was mentioned as one of the preempting tools or any kind of possible contradiction between either the protocol in other provisions or provisions within the protocol as well. And I would like to read some Article 2 of that safeguard clause, which says, in the event of a contradiction between two or more provisions of this protocol, the interpretation which favors the rights of persons with disabilities and protects their legitimate interests shall prevail. So here we have the best interests of persons with disabilities as a threshold as well, just as we have the best interest of the child in the African Children Charter, in the CRC, and those instruments. Thank you.
Mine is not a question, but it's just to reinforce again the issue of safeguard. I think when you are doing the comparison of CRPD and the ADP, we have to be extremely careful not to undermine what each of the instruments is doing to advance and protect rights of persons with disabilities. And I like that at the end, there is that emphasis of the safeguard clauses. But I think it should actually be at the beginning of every presentation that is comparing the CRPD and ADP, unless it's a novelty right that is being discussed, like the way the UN Special Rapporteur on albinism, the issue of harmful practices, that is very clear. It's a right that is actually guaranteed under ADP. And when you look at the CRPD, maybe it's a right that has been interpreted through interpretation of the CRPD through the concluding observation. But when you look at the ADP, it's very clear it's a right. So I think it's very important as we create awareness about the ADP that we keep reinforcing that the two instruments are reinforcing each other and there's none that undermines the other. I think it's very important when you're creating awareness that we keep the safeguarding provision as a key provision of enlightening and creating awareness why we need the two instruments and any other law that advances rights of persons with disabilities. Thank you.
I have a question with regard to sexual reproductive health rights. So I see the formulation is more or less in line with the Article 14 of the Maputo Protocol. But there is so the Maputo Protocol expressly then states must ensure safe abortion, etc., etc. And my question is, the exclusion of that specific provision in the ADP with regard to access to safe abortion specifically, was it deliberate? Is there anything there to know? Why is it not mentioned explicitly the way? Because I'm saying this because in terms of the general fertility access to healthcare decision to decide on spacing, in our states, the way people interpret it, when you don't expressly mention the right to access to safe abortion, it doesn't necessarily include access to safe abortion, which is why the Maputo Protocol, that provision in Article 14 is important, because it then creates the obligation for states to ensure access to safe abortion. So my question is, why isn't abortion mentioned expressly in the ADP?
It's a one more here.
Also, just to follow up on my learned colleague's comment there on abortion. In Namibia, we have the Abortion and Sterilization Act, where forced abortion is allowed by a medical practitioner in the event of likelihood of disability of the baby. I think within the first trimester. I'd also like to hear your views in terms of the right to bodily autonomy regarding having that choice taken away from the individual, and also that the ground for abortion be disability. Thank you.
Sorry. At the National Disability Council.
So yeah, thank you for those great questions and comments. And I also open up the floors to people who might have maybe better responses than I may have for the questions that have been raised. But first, just to mention that I'm aligned. I agree with comments from Dana about safeguarding clauses. And really, it shouldn't be a competition between the two provisions. But we need to also understand the distinctions between the provisions and see how they apply and in what context, especially now that we are moving to the next phase of implementation of the Africa Disability Protocol, or requiring more interpretation of the specific provisions in this regard. So on the question on IVF, my simple response would be in a state, or if local or national laws recognize IVF as an individual right, then that right should apply to everyone, including persons with disabilities. Because the general approach when it comes to disability rights, because we realize that the Convention on the Rights of Persons with Disability or the protocol do not create new rights. What they do is to contextualize the existing rights, but with respect to persons with disabilities. So in the same regard, state parties under the principles of the protocol and the CRPD should also expressly recognize that this right applies to everyone, whether they have a disability or not, and where necessary, also provide context-specific or undertake context-specific measures which apply to persons with disabilities. Yes, and then with respect to abortion, the right to safe abortion is not expressly recognized under the African Disability Protocol. And I cannot I don't have a good response to why. But what I would say is, going back again to the safeguarding process, that the protocol rights on sexual and reproductive rights should also be read together with those of the Maputo Protocol, I believe Article 14, that persons with disabilities also have the right to access safe abortion, just as provided for under Article 14 of the Maputo Protocol. And in this regard, then, it would take, different states would take different approaches and in implementing that provision, because some states such as Kenya have a reservation on that specific provision under the Maputo Protocol, I believe Uganda as well, and others don't. So it's a gap within the Africa Disability Protocol, but the Maputo Protocol also applies to persons with disabilities. And then, still with respect to abortion, unfortunately, even in states that criminalize or do not recognize abortion as a right, and which should not be the case, they still recognize abortion, or some still recognize abortion where it is identified early that the child might have a disability. But more, even beyond that, some laws, especially within mental health laws or criminal laws, they also or practices, within practices in states, they also exercise unsafe abortion when persons with disabilities get pregnant, especially persons with intellectual and psychosocial disabilities, for reasons that I mentioned, that they are found, societal norms find them not to be safe, or they believe that the person with disability cannot take care of the child, or the person with disability might get a child who has a disability. So in that regard, then I would still stick with the provisions under the protocol that sexual and reproductive rights should be established or recognized for all persons, including persons with disabilities. A possibility of a child having a disability should not be a justification for undertaking unsafe abortion. It should not be a justification. Otherwise, most of us would not also be in this room. And thirdly, I think it's important that the gaps that we are identifying in this conversation. So, for instance, the failure or the lack of a specific provision on abortion should be presented before the African Commission, which has a mandate of interpreting this law, so that in its normative framework, it also aligns the provisions under the African Disability Protocol to those of the Maputo Protocol.
Wilson, if I can add something from the second. So this is in relation. So this is in relation to whether abortion should be omitted when a woman finds out that the fetus has certain conditions that would lead to an impairment. So in 2018, the CRPD committee and the CEDAW committee adopted a joint statement on sexual and reproductive health and rights of women with disabilities. And I'm going to read this part of it, and then I will share also what has been the practice from the committee in relation to interpretation of the permissible options for women to have abortion within the law. So what the joint statement reads is that states should acknowledge that women's decisions about their bodies are personal and private, and place the autonomy of the woman at the center of policy and lawmaking related to sexual and reproductive health services, including abortion care. This is very specific to women with disabilities. So they have to be at the center of making decisions of whether to have or not have a child, and whether to take to have an abortion within the framework of the law of that country. And when you look at Maputo Protocol, it's actually one of the provisions, Article 14.2c, it's one of the provisions that has very expansive grounds of when a woman can decide to have or not have abortion.
And the practice from the CRPD, it is that when you legislate and state that a woman include disability or an impairment as a ground, then that's actually disability-based discrimination. But if the provision is from disability-neutral approach, applying that when the life, when the health, all those provisions that are broad enough to allow a woman to make decisions, but not to specifically say because of an impairment. So you're not terminating a pregnancy based on an impairment, but does that pregnancy actually affect the health of the woman, whether it's mental, physical? Is it an issue of rape and sexual violence related? So all those approaches are very disability neutral. But when the law explicitly includes an impairment as a ground for termination of pregnancy is actually disability-based discrimination. But what that is reinforcing. Thank you, Dan. And then what we need to learn is that just like any other woman, when we say the issue of autonomy, the principle of autonomy does not apply just to women without disabilities. It applies to all women, regardless of whether you are a woman with disability or not. So you as a woman, the autonomy to make a decision about your body is up to you. And whether you're a woman without disability, and the autonomy to make a decision of whether to terminate a pregnancy or not is about you and your decision, as long as it lies within the law of that, because different countries have different laws, but the standard is Maputo Protocol. I will keep on saying that the standard is Maputo Protocol because it has expansive grounds of permitting safe and legal abortion for all women, regardless of whether you have disability or not. I just wanted to reinforce that. So it will be great if you can reflect on the 2018 joint statement, because it was essentially bringing a consensus between the CRPD committee and the CEDAW committee in line in relation to interpretation of access to safe and legal abortion for women with disabilities.
Thank you very much, Miriam, for that. And also just to emphasize, although we had this conversation yesterday, with respect to the legal capacity of persons with intellectual disabilities.
Sorry, can I just quickly, before we move from that point from the colleague, what about where abortion is not legalized within your country? I know in South Africa it's legalized, but what if in your country it's not legalized? How does that apply?
Then it will still go back to the interpretation of the law. What takes precedence? Like in our case, we can use the CRPD, we can use the Maputo Protocol as long as the state has ratified and no reservations. But we can also use, okay, now you're saying that domestic laws do not permit. But it's about now the international laws and whether they can be interpreted, and if you can seek an interpretation from court. So for instance, in 2018, Center for Reproductive Rights, when was that? 2018, 2019, yes, 2020, 2018. Kenya has different laws when it comes to issues of abortion. And so while the Constitution permits abortion in certain grounds, we also have the Sexual and Violence Act also, which has broader provisions about access to abortion in cases of sexual violence. So it's the court that made that broad interpretation. So interpreting the issue of the Constitution, the sexual violence, so looking at where the loopholes are and expanding or elaborating the grounds of permitting legal, safe and legal abortion within a context. So for us, it's the courts that have helped us. Of course, it's in the Constitution under certain grounds, but then harmonization of laws has made it because we challenged, and I say we challenged because I worked for Center for Reproductive Rights then, and we challenged the provision of safe and legal abortion when it comes to issues of sexual violence. And Kenya still has a reservation under Article 14 QC, yet we still challenged that reservation by seeking the interpretation of court, what it means of safe and legal abortion in cases of sexual violence. And so it's the court that helped us. The government is still challenging it. There has been several appeals about it, but then that's what we use nowadays, the judgment that came interpreting and elaborating that. So perhaps then the question will be using strategic litigation to seek the interpretation of court, to see whether you can use, I think you mentioned that in a way it's directly applicable in international law, but then the domestication is another process, so the interpretation and application can be sought from courts to see whether that can guarantee safe and legal abortion.
Thank you.
Thank you very much, William, for that response. And unfortunately, in most cases, we'll always go back to the conversation of non-list versus dual-list, how international law applies in your specific context, in your specific countries. But there's also been instances where, so South Africa could be one case in point, where even though a law has not been domesticated, has been ratified but not been domesticated, the Constitution allows for the court to use international law, that kind of international law as an interpretative tool, right, to help expound the laws, the national laws that we have. I think I'll end my presentation at that. Thank you very much for the participation, and I'm sorry that my technology failed me at some point. Yes.
Thank you so much, Wilson, for that presentation and contributions from the floor. Now we're going to go on a tea break for like 5 minutes because we're behind on time. Yeah. Yes, 11:05. You should all be back. I mean, take your tea if you have to. Yeah. After the break, we'll have a panel discussion. Thank you.
Why are they taking sweets?
This is unhealthy.
Yeah.
Very unhealthy. You have a full breakfast, then you have a tea break, in between you have sweets, then you have a big lunch, sweets again,
Yeah.
tea break. Oh,
I used to take this, but now no more.
yeah. You know, the sugar in it.
Yeah,
I take some and I leave in my bag, so I never when I'm in my room just to snack.
maybe I'll just take like in case I'm tired. But
Or a sugar cake.
I would finish this on my own, right? Most conferences.
I love the endearments.
Mm.
Those ones, the soft ones, the ones in the
Oh, those ones.
yeah,
I mean,
white and green. I know those ones I can finish with my eyes shut.
I mean, I would finish any type of sweet. But now,
You're going healthy.
yeah.
The older we get, the healthier we
You know,
become.
yeah, health is the new wealth.
It's the new world.
Just plain coffee, no sugar. No sugar, just, yeah.
LinkedIn is trying to get me on this premium thing for a long time.
Right.
Just avoiding.
And
Are there benefits to premium on LinkedIn?
no, I've never used it. You know, the thing is, you end up having a lot of subscriptions, you know? And it's
Because also for me, I had the Google for my Gmail.
I'm fine.
I'm good. So how are you? I had the one for Google for my Gmail,
Okay.
and then I changed my banking details.
Yeah.
So it declined, and then you just get the notice that payment. I'm like, what payment is this subscription? Google.
Me, I
And I have
ended
to
up
go change payment method again.
I ended up opening a Yahoo account because Google always tells you it's full. You need to.
Yes.
Yeah, you know, so.
No, I opened up another email for the consultancy, so I used more than one email.
Okay.
But
So
the
you
passwords
too.
threw us out. There's too many passwords.
Yeah, a lot. And you can't use one because it
It's a
becomes,
risk.
you know.
It's a risk. It's a security threat. Everything you get something. Is it plain? No.
Yeah.
Sorry, but no sugar.
No. I'm trying to be healthy, my sister. Health is the new wealth. You can see I'm a big boy. Yeah. So,
all right.
so next time you see me, I'll be modeling.
Okay. All right. Why didn't you say that?
I'll have lost weight. Hi there. Are you part of the ICJ? Oh, it's only him. Oh, okay. So how can I engage? I hear they're having a workshop on targeting people with disabilities. Yeah, I wanted to go there, but you can see. Yeah, yeah. Capacity building. Is it? So you also in the legal.
I am.
What do you specialize in?
So I have an interest in human rights and disabilities.
Okay.
However, I'm currently practicing in Kenya.
Yeah.
And so in the law that I'm in, we basically handle conveyancing, commercial,
Okay.
release, and a little bit of human rights.
Oh, human rights normally it doesn't bring the money. It doesn't bring
So
it.
that's what everyone says.
Yeah. I'm also in attorney. I've got a small law. I've got a law firm. I don't want to call it. So we do commercial litigation, notarial work. My wife does it. Another job. Yeah. But I love the disability. It's lived experience.
It is.
Yeah, you know.
It is. Because you see, once you're in the office, all they do is, people work, and you don't get to see the in this space,
Yeah.
you get to deal with real issues.
Yeah.
There's just commercial transactions.
Yeah, you're right. Yeah. But I didn't agree with his answer on IVF. I think they call it specific need now, not as opposed to special need. And it doesn't mean that if it's not accessible to people, the general population, it shouldn't be. The government should actually provide it to those who need it. It's the same way they provide braille, ramps. It's a specific need that actually affects the right for someone to actually space his pregnancies and the like. So, but our governments will always say resources don't permit. And how many people with disabilities can actually afford the private sector? Yeah, it's something else. So I heard there's a strike in Kenya.
I think this is a season. It's a season to strike. Demonstrating.
Okay.
Yeah, so it's not the Gen Z.
Yeah.
It's the doctors, it's the doctors. We have now the teachers and the lecturers.
Oh, okay. Yeah, but I think that's how you make government work.
In Kenya, yes. That's the only way they get to listen to people.
Well, other African governments are actually oppressive. You don't have that right to strike willy nilly.
True. I remember there was a time when Kenyans were joking after the Gen Z's demonstration.
Yeah.
They were arrested and detained.
Yeah.
I think that's why they were arrested as a country. We clearly have a
Yeah. And in Zim, the president actually told them, try it. So yeah, it's tricky. Yeah, it is. You should.
Sometimes you even forget there are other people.
Oh yeah. We got five. No wonder. There are how many?
69.
69. 69?
It's only those up there. Okay.
Was it by invitation or it was by invitation?
I've just noted it. I've never attended. Somebody used to send me the links. I was in it, but now I know.
So how can I engage with your office?
With our office, anyway that we need to. We actually went to Zambia a few. When did we go to Zambia? 2 or 3 months ago.
Okay.
They have a very extensive information system.
Oh.
Very good, disability information system, and their OPD is also very strong in Zambia. So one of our mandates is to consult their OPDs.
Okay.
In terms of strength and development and advocacy capacity. So when we went to Zambia, and we're now busy with the cooperation in Cambodia so that we can exchange.
Okay.
Expertise, resources across the border.
Okay.
Maybe do transfers because they don't have a legal department in Zambia Agency for Disability. So I'm thinking of me going and helping them to establish.
Okay. Okay. And how do you help small DPOs?
Or you call them DPOs, we call them OPDs.
OPDs, yeah. Well, DPOs.
We provide funding to the DPOs, and we also provide support, technical support, and then also in terms of training. Like now, last month I had a training session with OPDs on corporate governance, financial management, auditing, and and our terms of funding agreement, how funding normally works with external donors, how can they protect their interests when getting funding requests and from external donors.
Okay.
Yes. Support and training.
Oh, okay.
Depends on the need.
Yeah, yeah.
Depends. And money is obviously a big problem.
Yeah, that's where external donors come into play. You really
Your
need to-
organization is a DPO.
It's a DPO. Yeah, but it's still growing. Yeah, and trying to build capacity. Yeah, capacity building is a major concern, and yeah, forums like this they really help. Yeah.
Ours don't have the funds to travel to forums like this.
Yeah, I do. Yeah, I do understand.
We had our chairperson of the Wheelchair Users Association. He was actually presenting 2 weeks ago at Oxford on the intersection of the legal theories and disability and how religion impacts stereotypes around disability.
Hi, Wilson. I always confuse you with Brian Muchira. You know Brian?
Brian who?
Muchira is this?
Mashira.
Yeah, yeah, Machira. Yeah.
Oh, from Kenya. Huh?
You are from Kenya. Yeah. He's a YouTuber that advocates for
Oh
disability.
no, yeah. He's called Julius.
Oh, he's called Julius.
The YouTuber.
Yeah. There's one who's quadriplegic. His name is Brian.
Ah, yes.
Yeah.
Okay. No, I was talking about the different person.
Yeah.
We look alike.
No. The accent.
Okay.
Yeah. So yeah, my name is Aaron Mupeti. Yeah, I'm a director of a DPO called African Disability Initiative on Reproductive Rights.
Ah, fantastic.
And I'm also an attorney for our law firm, Mupeti Attorneys.
Ah, okay.
Yeah. So yeah, it was nice to hear your perspective on reproductive rights.
Reproductive rights.
Yeah.
Thank you for your contribution. Also.
Yeah. Well, yeah, I'm still
I'd like to hear what you're doing in.
Hello everyone again, will we get started?
I'll make sure we mark your face and we have a chat.
Okay.
Oh no, we're good. I'm good shot.
Hi again. Like I said before, we're going to have a panel discussion that will be facilitated by Mr. George, who is a senior program officer, Disability Rights Fund, / Disability Rights Advocacy Fund. I'm going to hand the mic over to him to introduce the panelists. Thank you.
Okay, good morning, everyone. Is to implement the African Disability Protocol. And for to reflect about those, possible strategies, we have three guests. On my right, immediate right, there's Dr. Elena Combrick, Professor Ellen Combrick, who is an associate professor at the Faculty of Law, Northwest University, where she teaches both undergrad and postgraduate level. She has previously worked as a senior researcher at the Center for Disability Law and Policy, University of Western Cape, in Cape Town, which was preceded by a number of years of the project coordinator of the Gender Project at the Community Law Center, also at the University of Western Cape. Her publication focuses on disability rights as well as gender equality, with an emphasis on gender-based violence. From 2016 to 2017, she was the member of the task force convened by the International Bar Association, Human Rights Institute, to examine the rights of persons with albinism. Currently, current research interests include the rights of persons with disabilities, persons with psychosocial disabilities, and the development of disability rights in Africa. Thank you so much for being here. The second guest is Dr. Thomas Ngolo, who holds a PhD in curriculum studies, majoring in inclusive online curriculum development, and a master in disability studies. He has a disability lived experience and has worked with different organizations across Africa. Some of those organizations are African region-based organizations of persons with disabilities promoting disability rights. He also worked for the African Union Commission as a special advisor, supporting different disability rights instruments, reporting on the African Decade of Persons with Disabilities, 2010-2019, adoption of the Disability Protocol, drafting of the African Disability Rights Policy. Currently, Dr. Thomas Ngolo is a GIZ Regional Disability Advisor for Africa, supporting development cooperation on different regional and bilateral empowerment initiatives. Thank you so much, Dr. Thomas. And last but not least is Miriam Lenge from Kenya, who works for International Disability Alliance. Miriam Lenge has an LLM, International and Comparative Disability Law and Policy. She's currently a human rights advisor at International Disability Alliance. Miriam has vast experience in research, advocacy, movement building, legislative and policy analysis, and is a strong advocate of human rights monitoring mechanism as a key agent of change. She has extensive experience in African Union and United Nations human rights mechanism, gained for serving in different roles at Kenya National Commission on Human Rights, the former UN Special Rapporteur on the Rights of Persons with Disabilities, Catalina de Vandas, the Center for Reproductive Health Rights, and currently at IDA. Miriam is keen on evidence-based advocacy and has authored scholarly paper on accessibility, inclusive education, inclusive employment, legal capacity, sexual and reproductive health rights, and the role of national human rights institutions as independent monitoring mechanism. So welcome everyone. We have, I believe, approximately 1 hour and 30 minutes for discussions here, but also engagement with the platform, with the panel, with the room, the participants. I have a few questions to ask that I prepare for the panelists, but before I throw the questions, I want to give each of you 5-10 minutes to reflect on the main question that brought us here, which is strategies for implementation and the personalization of the African Disability Protocol. From your experience, but also, the potential that the fact that comes with the adoption of such instrument brings. So I'll start with you, Dr. So the first 5 minutes.
Good morning, everyone. I have a couple of thoughts to share. I decided to call my brief input this morning, supersizing the protocol. I think I was hungry at the time, so I was thinking about a well-known burger franchise, which is how we got to the supersize aspect. So the first part of my short presentation, I call choosing your meal, your main meal. And the reason why I say that is because I think that the disability protocol, as with many other international instruments, holds a lot of potential to such an extent that I think each organization, each individual who wants to engage with the new protocol, and new in the sense that it's now really in force, would have to look at a very directed strategy or a number of directed strategies. Let's say, for example, that you decide that the way that your organization wants to use the protocol is to develop jurisprudence. In other words, to get comments, views from the African Commission on Human and People's Rights about the interpretation of the protocol. First of all, one would have to look at what the existing history has been. Why is it that in 20 years, even longer, the African Commission has only heard or dealt with one complaint regarding disability? And the answer is quite simple. It's because only one case, one admissible case, has been brought to the African Commission. The African Commission, as with any judicial or quasi-judicial body, can only decide on what is in front of it. So if you decide that you want to develop the jurisprudence, you're going to also have to think about how you are going to get those cases before the African Commission. My personal, just as an aside, I think my personal explanation for why there aren't more cases is the same reason as why we don't have cases brought under the Maputo Protocol, and also why we don't see more disability rights cases at national level. It's first of all the fact that many organizations working with either women's rights or disability rights are not aware of the potential of these instruments. And secondly, it's not a question of just winning that case. You have to first exhaust all of your domestic remedies, and all of these different stages take resources and money. So I think that those kind of reasons all hold together for why we don't see a better developed jurisprudence around disability before the Commission. Then the second part of what I would like to just briefly look at is I call add your side dish. And here I'm basically thinking about developing coalitions. For example, if your organization has observer status with the African Commission, as I think the Centre does and a number of other organizations,
I think it would be a good idea for disability rights organizations to partner with the center or other organizations that have observer status, because then one can think about developing guidelines for the Commission when it is assessing or considering state party reports. I have to confess that I was one of the protocol skeptics. One of my main concern was the fact that I didn't feel that the implementation or the implementing body, which would be the African Commission, would be robust enough. And the simple reason for that is if you load enough freight on a ship, eventually that ship is going to sink. And that is my concern with the African Commission, because it already has a great deal to monitor. But thinking about guidelines, even just 5 guidelines that the Commission has to consider when monitoring state reports will already give us a bit more implementation in terms of the protocol. And then speaking about litigation, here again, I think partnerships are essential if you want to develop jurisprudence around the protocol. We have to look at strategic litigation not only before the Commission, but also at national level. And you're not going to find those cases unless there is strategic collaboration between strategic litigation organizations, as we've seen with Southern African Litigation Center in Zambia, and disability rights organizations. And then the last one that I just want to quickly focus on in terms of possible partnerships and coalitions. We know that one of the major stumbling blocks in terms of getting cases before the African court, and that applies not only to disability rights cases, but all human rights cases with individual complainants, is that most of the African countries have not accepted individual jurisprudence of the court over individual cases, if I could put it that way. They haven't made the so-called Declaration 34 sub 6 that needs to happen. So once again, I think disability rights organizations can work together with human rights organizations in other spheres that are also contesting or trying to encourage their governments to make that declaration so that the court has jurisdiction. I'm getting a very strict stare from my left-hand side here, so I'm going to stop there, except to say, of course, at the end of your meal, you are going to ask, may we have the bill, please? Bill as legislation. Thank you.
Thank you very much. Thank you very much, Aline, for the background. It appears I can see several convergence in terms of thoughts, because strategies which I also subscribe to. There's need for a presence within the Commission, and as we speak, I think I was checking a couple of days ago how many organizations, especially disability rights organizations, that have observer status to the AU mechanisms, whether the Committee on the Right of the Child or even to the Banjul Commissions, because these are avenues for expression and especially galvanizing support. We know we have the NGO forum and then which cascades to the Commission ordinary sessions, which gives that platform for presentation of issues in this particular case, disability rights and for specific. Secondly, I'd also want to note that for the disability protocol, the ADP, to have meaningful, I think there's need for more visibility. And just a few weeks ago, a couple of weeks ago, in Nairobi, sitting with some of those commissioners, the commissioner, it's evident that we need to create that presence and awareness that as one case of Purette which was presented, we see another case, and that would be a test case. And I was happy listening to the exchange this morning. There is need for more interpretation of issues around access to justice, issues that talks about support to decision making, so that there can be clarity and interpretation by the Commission, and that will inform our countries. There's been also the issue around why is there a slow uptake of the disability protocol. As you heard in the morning, there are two models which we see, the dualist and monist, and some countries as we speak are reviewing their legislation. Togo, for example. We know they're saying that, okay, we have to wait until we align our constitution and legislation before we can adopt the ADP. And there are similar countries. The University of Pretoria traffic light matrix gives us an indication of which countries are on the red, the skeptics, slow uptake, and then there are those who are the amber, and we know those who are the green, who have the appetite and just need to be nudged for signatures and ratification. I think that's one strategy which we need, not to slow down the ratification and implementation. I think that's something which calls for still concerted effort. I think we started a long way as part of the disability rights, but we need to accelerate this interest and empathy. I think the other strategy which is also very critical, and I know it was mentioned yesterday by Lefoko, when we talk about implementation, how do we link the AU policy strategic framework, where we have 10 priority areas identified to respond to implementation of rights. You're talking about from what Choi talked about, right from the extreme end, from issues related to poverty to the extreme end, access to justice. I think these are some of the areas where we can make countries comfortable that it's not a shopping list that we are talking about when it comes to implementation. And and lastly, I think I would also want to say that for implementation to take place, there's still more visibility. I think we have not sounded, the ADP is mostly known within the convergent, within our spaces. You go to different offices, you don't see that blasted book poster talking about it. I think there is still much more which we need to do, especially related to more communication, more visibility, so that there is more sensitization, both within the whole judicial system, or general access to the whole ecosystem that talks about justice, or access to justice. Thank you.
Thank you, Thomas and Lynn. So when I was speaking with George about the past 5 minutes, I was asking,
what am I going to speak about? Because there's already predetermined questions that would cover everything. But then I reflected about strategy. When you speak about strategy, what are the key questions that you have to ask yourself? You have to ask yourself, what is the strategy? Who is the flag bearer? How is this strategy going to be implemented? And therefore, I decided that I would start my 5 minutes by speaking about who International Disability Alliance is, and as a flag bearer at the global space of promoting and advocating for implementation of the CRPD and the lessons that have been learned and how that can be replicated in the implementation of the African Disability Protocol. So I will introduce the International Disability Alliance. It's an alliance of 14 global and regional organizations of persons with disabilities, 8 global organizations of persons with disabilities, which include World Federation of the Deaf, World Federation of Deafblind, the English and International, the International Federation of Hard of Hearing, Down Syndrome International, International Federation for Spinal Bifida and Hydrocephalus, World Blind Union, World Network of Users and Survivors of Psychiatry, and World Federation of Deafblind. And then the regional organizations, of course, we are in the region courtesy of our regional member, the Africa Disability Forum, Troyes of the Park. And we have RIADIS, which is the Latin America regional organization. We have the Asian Pacific, which is for the Southeast regional organizations of persons with disabilities. We have the Pacific Disability Forum, and all these members give us a reason of being at the global space to advocate for the rights of persons with disabilities in both political processes, development processes, and human rights spaces. And then our main aim is to ensure that disability inclusion is included in human rights, global efforts in human rights, and development processes. So that's who International Disability Alliance is. Our approach is that we coordinate our actions with our members. And therefore, every space we identify at global level, there is a space for the Secretariat to address that space, but there's also a space for our members at regional level, at global level, to speak in those spaces and coordinate the national, the regional, and the global things that are happening to advance rights of persons with disabilities. So I would like my opening remarks to really focus who is the flag bearer, and then I will discuss about the how later on when responding to the question that will be raised. Thank
you. Thank you so much for this open remarks. We have, considerable time to go deep into some of the questions that we have here, but also to hear from the participants. So I'll actually start with you, Miriam, and the question would be either being in the forefront advocating for the full implementation of the Convention on the Rights of Persons with Disabilities at the global level. What strategies can you share with us that worked, but also perhaps things that, as we look forward to implement, push for the implementation of the African Disability Protocol, we should avoid?
So I'll start by reinforcing or reiterating what I said before about the African Disability Protocol and the CRPD. So whichever instrument exists, as long as the standards are to that of CRPD, we should see that instruments as reinforcing each other, and they're not competing. So that's the first rule of advocacy. It's that you have to see how each instrument provides an opportunity to advocate for rights of persons with disabilities, whether it's at the regional level, or whether it's at the global level, or whether it's at the national level. Having said that, and IDA existing essentially to advocate for rights of persons with disabilities and implementation of the CRPD at the global spaces, is that IDA has adopted 2 strategies or 2 advocacy, not 2 strategies, but 2 advocacy spaces. we utilize the political processes and the development processes to promote implementation of the rights of persons with disabilities. I'll come back to that and explain in detail. We also utilize the human rights spaces to advocate for rights to implement the full implementation of the Convention on the Rights of Persons with Disabilities. Our tools of advocacy are two. We have the CRPD and we have the SDGs. And we see both tools as reinforcing because of the fact that we want the CRPD to be the driving tool to implement the development processes. So we want a human rights-based approach applied in development processes. Starting with the human rights process, since 2008 when the CRPD came into force, and for the last years, about how many years, 2014, 2008, that's around 16 years, the CRPD committee has been holding 2 sessions in a year to review. So I'm speaking now about the strategy of state reporting and how that has been impactful in terms of ensuring the implementation of the Convention on the Rights of Persons with Disabilities. So the state reporting process has been one of the strategies that the International Disability Alliance has used to ensure implementation of the CRPD. And what is the role of International Disability Alliance in this? One is that we are a member of what we call TVNet, which is a coalition of different organizations, INGOs that support the different human rights treaties bodies to advance their work. We have the Human Rights Committee supported by the Civil and Political Rights Body. We have the Child Rights Connect supporting the Committee on the Rights of the Child. And then we have now IDA supporting the Committee on the Rights of Persons with Disabilities. And that support includes connecting the CRPD committee with different organizations of persons with disabilities. So our role is to ensure that we disseminate information coming from the CRPD committee to organizations of persons with disabilities, and therefore, and also supporting them to organize, to participate in the different processes. So when a country is coming for review, and in each session, at least 8 countries are reviewed by the Committee on the Rights of Persons with Disabilities. So we are looking at review 8 countries, so that's 16 countries in a year. And then we have also what we call the pre-session, which is now preparing countries coming up for review. So the pre-session is essentially to discuss the kind of list of issues, list of questions you want government to respond to as part of strengthening or providing additional information to the state report. So we support all of these to prepare the alternative reports. We support them to engage with the committee members. So we have what we call preparatory meetings, and these preparatory meetings can be either remote or in person, and they can engage with the country rapporteurs or the committees that have been, committee members have been allocated specific countries. Right now, the committee has what we call task force. It's a new methodology, working methodology that has been adopted by the committee, where you find 4 committee members supporting the review of a certain country. So that's the first strategy of state reporting. The second strategy is, of course, the development and elaboration of the different substantive articles of the CRPD, the general comments, and of course, there's a process of organizations of persons with disabilities bringing in their contributions and showing how what the interpretation is at the national level and the gaps that exist, and that helps the committees to be able to elaborate that. So that's the next approach when it comes to human rights processes. But we do not only focus on the human rights of the CRPD, we also move to the other spaces. And the question that Doug raised yesterday about the reflection that Doug raised yesterday about the inconsistency of concluding observation or jurisprudence that is coming from different committees other than the CRPD. So our role working together with OPDs is to ensure that these committees adopt the standards that have been developed by the CRPD. And we do this again by supporting OPDs to report to these committees, to contribute to the development of general comments, expanding on what the CRPD states and adopting the standards that have been set by the CRPD. In terms of development processes and how we use this
advocacy spaces to advance implementation of the CRPD is that we engage in the implementation of the Sustainable Development Goals through the high-level political forum. We are a member of the stakeholders group on persons with disabilities, and we have been very active in ensuring that the path for the future that has just been adopted includes specific provision and language that is in line with the CRPD. And of course, the Global Disability Summit from 2018 to the present. And now we ensure that during the Global Disability Summit, the commitments that are being made by states are actually in compliance with the CRPD. And we have what we call regional consultation, within country consultations, where OPDs engage with government agencies to ensure that the kind of commitments that are coming from government agencies, development partners, multilaterals, they are CRPD compliant. So all of these strategies are strategies essentially to promote implementation of the CRPD. Remember that I've mentioned both the political spaces, but also the human rights process. So you don't go to Banjul for the state reporting processes, and then you forget that you need to go to Addis during the summit, the AU General Summit, and ensure that you speak and advocate for implementation and ratification of the ADP. You have to ensure that both spaces are occupied, and you have to decide who is going to be your flag bearer in those spaces. For us, as an international organization of persons with disabilities, we believe that organizations of persons with disabilities have to be at the forefront of any advocacy and any sensitization and advocacy towards full implementation of the ADP, but also the ratification processes. Thank you very much.
Thank you. Just 1 second. Unless you want to take over the room. Thank you so much, Miriam. I think what you just said, it's really important in the sense that we are talking about disability-specific treaty, the specific protocol. But to make it, from an implementation point of view, we should be looking at engaging with other treaty bodies, right? So it's not about the institution or the organ that's in charge of the protocol itself but also with other mechanisms, including human rights, but also development. And as we remember yesterday, the presentation that Shoaib did, he mentioned that, one of the big challenges, actually, he put it, the challenge number one for persons with disability in Africa is poverty. So that means that we should be dealing as well with, decisions that are being, made around development and development strategies and so on and so forth. Thank you so much for that. Thomas, to you now. We know about this new strategy that just launched, which coincided, with the entering into force of the African Disability Protocol, but also aims to support the implementation of the protocol itself. Can you please reflect a bit about what are the contributions they hope to bring through this initiative?
Thank you, Miriam brought the perspective of the OPD from that global perspective, and I'm coming in from global but working with the development agencies. And the support of development cooperation, especially in realizing Article 32, has been seen across the different continents. And here in Africa, our collaboration with the African Disability Alliance, ADF, in that whole journey from retrieving the report, which was two protocols, the older person and the person with disability, and convincing Eileen, the next city next to me, that there should be one protocol. Was one of those journeys that the Development Corporation, especially the GSA and the government of Germany, has walked through to see that this instrument comes to fruition, and it now has entered into force. With that backdrop, we have also seen and acknowledged that there are still gaps. And whereas resources, both human capital and time and expertise, has been well allowed to make the UNCRPD realize and have impact in our continent of Africa through the help of IDA and the ADF and other players in the continent. I think there's still gaps. And one of those gaps that I think we have seen is our interaction as the OPDs in the content with the African Union system. Our sat in Addis and the Council of Ministers meeting special social development, we don't see that presence, whether at the Pan-African level, Pan-African Parliament level here just across the road, or when the ordinary sessions of the Banjul Commission undertakes its rounds across the continent, because it's not just sessions in Banjul, but we have seen the Commission moving around, and I think our involvement, especially as a civil society, I think has been not as evident walking through the civil society sessions and also just across in the suit here. For the first time, we saw very aggressive and robust involvement of persons with albinism 4 months ago at the session. I think that's the spirit which and the backdrop that GSA, the government of Germany, is now putting in resources as part of civil society strengthening. And the new project that you have sought to that I should put more information aimed to strengthen the voices of civil society, especially the organization of persons with disability in the continent, to engage with the mechanism. And we'll be partnering with the APEX, the African Disability Forum, and also have that reach to the regions. So we are looking at strengthening, getting that voice. We know we have a disability legislation in the Eastern African region, the East African Community region. We know there's a strategy in ECOWAS just adopted, and we know WAFOD, which is a regional, sub-regional, OPD has observer stickers within that kind of rank, Regional Economic Commission. And we'd like to see similar engagement by the African OPDs at the APEX level. The other component, I think, which this support will also focus on is building on dividends. GSN works across almost up to almost 50 countries in the continent, and that's quite a huge footprint. And to make sure that the portfolios in the bilateral corporations which we have also include disability, because we have adopted the dark marker that is making sure that all new projects from 2024 in terms of bilateral corporations, whether it's the German government supporting initiatives in Namibia or Cote d'Ivoire or to the extreme end in Egypt, there has to be an indicator that marks, that shows that it's the program is disability sensitive, disability includes, disability transformative. So the same elements and markers that we have used in in the gender marker is also now being used in disability indicators in the new project. I think that will then mean, other than just the support which we are getting, which we are giving, which we are supporting the EDP and the OPDs in Africa, will also, this initiative will create more sensitization, especially within the bilateral programs in Senegal, across Africa, so that we want to see the German Development Corporation walking the talk in terms of reach, in terms of impact. But lastly, which is also very strategic and very important, there is also going to be a collaboration with African Union Commission, and this support will operationalize the ADP. And I think that phrase, I think, is still open it gives that limits and the latitude how will the African Union make this protocol livable. And I think that's the beauty of this kind of bilateral cooperation, because then some of these issues that we have discussing for the last 2 days can be made to come into fruition in terms of the lacuna or some of these unspelled part of the protocol. What is this council that the protocol pronounces itself on? Is it just an administrative? Or will it have some quasi mechanism roles that then helps the Commission in the disability jurisprudence? I think these are some of the things that will also emerge from this bilateral cooperation. But for us, as part of the German government and GS, we're very happy that this is going to be a 4-year program. And it's our belief and conviction that these resources, if it plowed in, will promote disability rights across the continent. And of course, lastly, and this is also quite important, there is acknowledgement of data. And we believe that work package will be an opportunity to reach out to centers of excellence like University of Pretoria and similar disability experts across the continent to engage more with research and data, so that advocacy is more informed and more so policy directions are influenced, especially at the apex level. So this is going to be a Pan-African initiative which is being supported, and very little direct reach at country level. So the country level will be through our support to our bilateral cooperation, but the main program will be at the apex level and engaging through the African support of the African Disability Fund. Thank you.
Can you spell out apex so everyone understands what you mean?
I've been asked to, what does this one apex mean? I think it was used earlier. The apex code. No, we know that the architecture of the disability rights organizations in Africa, there's one political disability rights organization, African Disability Forum. So that's the apex. Under that, I think we saw the list of those different organizations, continental organizations that are affiliates of African Disability Forum. That's what I meant as the apex as a continental Pan-African organization. And the sub-regional organization are those which are mentioned within the ranks. And for example, this initiative will not be supporting a small program in Gweru, in Zimbabwe, or in the border of a place called Sanka in Senegal. So that's what I mean, because we, as she has said, have bilateral cooperation between Germany and Senegal, or between Germany and Zimbabwe.
Thank you, Thomas. I think, still there's the goal of having at least a multi-layered approach to it, although you will not be directly involved at the national level, but you acknowledge that there's a space for GIZ at each country also to play a role. It's very important, and then to be able to connect those efforts at the national level with the work that the initiative will be leading at the regional level, either supporting ADF as representative of African OPDs, but also the Commission directly. I think that multi-layered approach is very important for the implementation of the protocol. Thank you so much. To you, Dr. Ellen, I wanted to ask you to perhaps reflect a bit about, I mean, this is one kind of additional protocol. So in the morning we are talking about the Maputo protocol, many other protocols that exist already at the continental level. And my question would be, what can we learn about implementation of those other protocols? So what are the do's and what are the don't? Thank you.
Okay, thank you. I'm going to largely focus on the Maputo protocol because I think that is where the clearest comparison perhaps lies. I think that one of the major problems, and people must please, if I don't get to the bottom of the problem, please add your perspectives. But I think one of the remaining problems with the Maputo protocol is that decision makers at national level are not yet aware of the protocol and its implications. It's a kind of a smaller microcosmos of what is happening at the global level, where governments are very quick to ratify, but then it's left there. I think that is the first thing. I have already spoken about the question of bringing complaints to the African Commission, where we see the same gap under the Maputo protocol as with disability rights generally. And I do know that there are litigation organizations trying to address this. But of course, you can't come up with a case on your own. The cases have to be brought to the organization first and then to the commission. I think something else that we learned from the Women's Protocol is that in terms of the commission's review of state party reports, one has to make sure that the Maputo Protocol stands out. Because even if you have obligatory reporting guidelines that guide states in how they report on the implementation of the Maputo Protocol, that is only going to be valuable if the Commission calls them on it. And I think that is a lesson that we've learned, is that if states do not comply with including the required information on the Maputo Protocol, it can easily just slide under the table. So I think if we're talking about the disability protocol, we have to make sure that the monitoring stays uppermost in the minds of the African Commission as well, because I think that is another lesson from the Maputo protocol. That's more or less my contribution around that, but I just want to say to Thomas, on the protocol, I wasn't convinced so much as outvoted. So, just so the record is clear.
Any of you want to reflect on this last question? Protocol or any other protocol, what we can learn with previous protocol?
So this is my experience at the African Commission, not at the UN. And of course, using the Maputo Protocol as a tool for advocacy, because my presence there was essentially to advance sexual and reproductive health, which is very strongly anchored in the Maputo Protocol. And I agree with again, the issue of government understanding what Maputo Protocol means and the issue of reservations. So you will see that Maputo Protocol, a number of countries have put reservations under different articles, especially Article 14.2c, which is about second reproductive health. So the issue is about reservations and how to overcome reservations. Now I'll shift again. There should be a seat here for National Human Rights Institution, because when I speak about regional and international obligation, there's a very powerful tool, powerful role that National Human Rights Institutions plays. And to overcome reservation, one of the ways is to ensure that National Human Rights Institutions are providing those advisory opinions to government, why they should ratify, they should remove the reservations. And for instance, in Kenya, I've seen the Kenya National Commission on Human Rights writing advisories around how to ensure that reservations are removed under the Maputo Protocol for Article 14.2c. So as we promote ratification of the ADP, one of the lessons learned in advocacy at the African Commission is to ensure that, and of course in Addis, because of the ratification process, is to ensure that you get clean. And when I say clean, ratification means that the entire instrument is ratified without reservations, because states are likely to put ratification on areas that they think that this one, we don't think it aligns a lot with our practices, but yet it's a human rights standard. They will also use justification of lack of resources to put in reservations. So you want to push for complete ratification of the instrument without reservations, because reservations will limit. So imagine if a country comes and says that we are going to put reservation on Article 7, on legal capacity, because of the fact that the protocol says that everybody is equal before the law, and all the issues that you're going to receive from the Ministry of the Legal Department that advises the government in terms of ratification. And that's why the role of now National Human Rights Institution comes in. So it's very important as a lesson learned. Please avoid reservation where you can in either of the articles, because all these articles are interrelated. And especially Article 7, we have to pay special attention, because there's a precedent already at the UN level that some countries put reservation on Article 12. So we might also see that replication, because there's also that thing of, what is the practice at the UN? We have seen a number of countries making reservation on Article 12 and Article 32 on international cooperation. So it will be very important that we also watch out the practice of what is being borrowed, which is not a good practice. But we must also watch out for what is being borrowed and is a good practice. So ensure that the advocacy for ratification is for the entire instrument, and engage at national level with National Human Rights Institution when pushing for ratification, to ensure that they fulfill the mandate of advising the Attorney General and the state in terms of why they should ratify the protocol. Thank you.
Thank you. Maybe I can also just add, normally synergy in terms of the advocacy that all of us, especially from the disability sector, promote. I think we have seen not just the protocol of Maputo, but what Wilson mentioned earlier during this session, the Marrakesh Treaty. And whereas we know that the Marrakesh Treaty came much later on, there's been the same advocacy. And we have seen the advocacy towards ratification of the ADP being overtaken by the Marrakesh. And for me, I think it's a complement. It's complementary, because, for example, in Ethiopia, which we know, that there was quite aggressive promotion and lobbying, because that's where the action was towards the amendment and final adoption of the ADP. And Ethiopia as a country ratified the Marrakesh Treaty, the same to Botswana. So I think it also shows us that our advocacy can be complementary, and the result, yes, it might slow down the ADP, but ultimately we know that in terms of promoting disability rights, in this particular case, for the Marrakesh Treaty, I think the two countries were very successful.
Thank you. Just to add to what Miriam has mentioned already, if you look at reservations under the CRPD, Article 12 is by far the article that bears the greatest number of reservations. So I think that is something that we can try to be proactive around, because my sense is that Article 7 is definitely in peril as far as reservations go. Maybe to raise something, it's a principle that exists under general treaty law, which is used very seldom at the UN level, and I think rarely, if ever, at the African regional level. And that is the principle that if a country makes a reservation, that reservation cannot go against the general purpose and spirit of that particular document. So my argument would be that any country registering a reservation excluding legal capacity under Article 7 is actually going against the very spirit of the protocol. Now, what can happen is that another state party can actually challenge that reservation. As I say, it's been done under the CRPD to a very limited extent. So, for example, if South Africa now goes and registers a reservation around Article 7, another state party, let's say, or a member, if you are going to use the right terminology, such as Kenya, for example. I like using Kenya as an example because they're quite adventurous as far as these things go. Kenya can actually say to the Commission, actually, that reservation should not be permitted. So it's also a mechanism that we can think about. It's quite a confrontational one, whereas I know that the general approach within that treaty space is to encourage countries to remove reservations rather than to confront. But it's something to think about, let's say, if all other strategies have been exhausted. We're really seeing that this reservation is impeding legal developments.
Thank you so much. Well, at this point, I wanted to pause a bit to pass the mic to participants for questions, comments. So I see 1, 2, 3, 4 hands, 5. So let's start from this side and back to Wilson.
I must say that I share a reluctance on relying on the African Commission. We currently have a more than 5-year-old case before the Commission, which we ask about every year.
That the center enjoys with the human rights, with the African Commission, that we have to leverage because it enjoys that space very well. Yeah, and I don't like all this. So one thing I don't know it's still there, but the microphone.
The executive secretary of the African Commission is an alumni instead, so that's
excellent advocacy. Yeah, so when the Center for Human Rights is reading its statement, ensure that you push them to put something on disability because their microphone never goes on. There will be given an extension because they know that once they switch off the microphone, they will not get the legal assistance support that they get from the center. There are many benefits of those relationships that you can reap and ensure you keep that relationship. So in terms of working in silos and the way we can cure it is all about that. And then the issue of timely publication of information, this has been problematic for the African Commission. I can assure you the committee on the rights of the child, the Lesotho now is at Addis. They are, if you go to their website, they are more even in terms of timeliness of information easier compared to the African Commission. But they have started trying. Over the years, I've seen that they're trying. The issue of resources, I'm looking at Thomas with good eyes, not bad eyes, that we need resources to support the African Commission to be able to advance its work. Because when you compare the African Commission and the UN, the human rights treaties, I have all the information, it's just click, 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 click. Everything. The concluding observations, if they're supposed to be out within a week, they will be out on that Friday, you know, so all that information. And then I'll move to the issue of ratification and say that ratification is a diplomatic process. So it means that you have to understand what these states care for. It's diplomatic, but you have to use the diplomatic process, but also use the human rights process. Thomas just spoke about the Global Disability Summit. The Global Disability Summit brings together a lot of member states to that space. They are making commitments now. As one of the outcomes of the Africa Disability Conference that was convened by the Africa Disability Forum, there was that universal call that we need to have the African Disability Protocol ratified. And therefore, as part of issues to be addressed in the Global Disability Summit 2025, under the specific pillars, we have 4 pillars that are going to be addressed next year. We have the non-discrimination, we have the socioeconomic rights, we have accessibility, and we have situation of risks. And for you to address non-discrimination, equality, and participation, the African member states need to ratify the protocol. So what you do in this process of government deciding the commitment for next year, don't wait for Banjul. Engage in the process of designing commitments, because you have seen very progressive implementation of the commitments made under the Global Disability Summit. Ensure that the commitments that are coming from countries that have not ratified the protocol, there's a commitment under Pillar 1 on non-discrimination for that country to ratify the protocol. And then you give reason, because it defines all these things about disability-based discrimination and everything. So that's one of the advocacy. Secondly, we have, as a lesson learned for the universal, almost universal, close or near, whichever English word is for the CRPT, as the most ratified instrument, international instrument, is because we have member states who are like, what do you call them? Like they are friends of CRPT. So we have member states like New Zealand who essentially support. They are there, like it's a group of few countries that took the responsibility of ensuring that they promote CRPT. So they have that conversation. They can convene member states because of that peer thing. So it's a peer conversation. So our peer conversation is very important when it comes to member states, because they respect, they respect each other and they listen to each other. So also look for countries that have ratified. I'll tell you, try and quote Kenya. Kenya is very good. Not because I am Kenyan, but try and quote Kenya and look the countries that have already ratified. Look for countries that are progressive, quote them, and try and figure out an activity hosted by them. So you can support them and tell them, this is what we want, and we want it like this. Can you help us? Because we want as part of ratification processes. So have, as part of advocacy, that peer conversation among states. Not you as Center for Human Rights bearing it, but identify groups of the ADP, similar to that of the CRPT. Friends of the ADP, member states who can really be the flag bearers, and that's what I was asking. Who is the flag bearer for any strategy that you're adopting for ADP? And then embassies as well. That strategy is very good because it's a diplomatic one. The embassies, the AU representative in that needs to show it to Kenya, for instance, or to whichever country at home, that there is that need to ratify. So engage the AU representative for each country in Addis. During the summit, ensure you are there and speak to different member states. That's actually the time you can have
a small evening with the friends of ADP member states speaking to the others on the importance of ratifying. Then the human rights process now of ensuring ratification. You don't essentially need to wait for your country to be reviewed by the African Commission for you to get a concluding observation that calls for ratification of the IDP. You can still use the UN processes. So look for countries that are coming up under the review of CRPD specifically within the region, because we have seen practice that the CRPD committee is actually making concrete recommendations under Article 1 to 4 that the countries needs to ratify the African Disability Protocol. So use that UN process as well to get that concluding observation. So you have this commitment that is coming from Global Disability Summit, you have the concluding observations, then you have the diplomatic process that is coming from Addis back to the country. And as you do that, prepare the ground at national level. Engage with national human rights institutions, ensure that they are pushing the Department of Justice. And if there is a treaty body that is a treaty agency, for instance, in Kenya we have a specific office that deals with treaty, other than just the Ministry of Legal, there's a specific desk that deals with treaty ratification. So if you have that, utilize that as well. I'm giving an example of Kenya a lot. We have already ratified the protocol, but again, those are lessons learned. So please, even when we are creating awareness of ratification, let's ensure that we give a holistic approach of how we can conduct our advocacy. And then the last thing is on the reporting procedures. And it's all an issue of what do states care for. Have you ever had members of parliament complaining that they have a lot of sessions, that the sessions need to be reduced? No. Because in my country, for instance, appearing in parliament, there's going to be a lot of allowances. They care about the parliament process because of the benefits they get. So what do states care for? And how can we leverage on this? The process of reporting, what the UN has done is to provide states with different options. So there is what we call standard reporting procedure, and we have what we call simplified reporting procedure. The standard reporting procedure is a long process that starts after the ratification, depending on the timeline for the first initial report. But after the initial report, states have an option of opting to the simplified reporting procedure. In fact, the Committee on Rights of the Child, it really emphasizes the simplified reporting procedure. And states have really adopted that option because it reduces the number of reports that they have to submit. But again, we don't want to give them an excuse because they always give excuse. Oh, this is slow. Oh, this one is, that one is. No, you always have to look at it from a positive way. But you have the option of simplified reporting procedure. Can you opt into that? So encourage them to opt into. And of course, you are speaking to the relevant officers that advises the government to opt for the different procedures. And you're also now, if they don't report the human rights mechanism, move into the SDGs, make sure that you're getting everything from there, move into other space that they care for, as you hope that they will still come back to the human rights processes. So I keep saying that let's look for what they care for and give them that what they care for, but from the ADP and the CRPD perspective to ensure that all the processes are done from a human rights perspective. And lastly, the NGO forum, why OPDs need to be there. It's because the declaration that is adopted and read at the beginning of the session and also reflected in the activity report, is it called activity report for the session, it shows the kind of the things that were prioritized. So you need to participate in the NGO forum and your message has to be one. We want the ADP to be ratified. At this particular stage, what we are asking for is actually we want the ADP to be ratified. We want the ADP to be implemented. So, so I think it's very important to occupy that. To date, I think it's 2 OPDs that have observer status, if I'm not wrong. Before, I used to see only AFO addressing the commission.
But observer status is not a limitation, and I'm sure you will tell me it's not a limitation. You can, as long as you're not addressing the commission directly, or you can also address it directly by ensuring that your hand is very high up during the panel discussion and you still be given the mic. But in terms of the session for situation in Africa, you are likely not going to make it because they will ask for your observer status. But the side events, the meetings with the communities, the alternative reports don't require observer status. You can always submit that. So that's what we can do as we move to getting observer status because it's critical and OPDs get observer status. Thank you.
I think that we've seen that there isn't just one correct strategy to work towards implementation. And I think that, well, I hope that we have raised a couple of suggestions across a broad range of activities to actually work towards implementation.
Yeah, I think my last word is that I would like to extend an invitation to all of you to next year's Global Disability Summit in Germany. We look it out on the website. There's a website, also the AIDA website, and also the Global Disability Summit website. I think it's what one would call the Olympics of disability and development globally. And I hope that's one opportunity of exchanging and learning lessons.
So my last comment is what I said from in the beginning. You must organize, you must occupy. It occupy and organize is a slogan we use a lot in Kenya, and that's what is helping us. Organize yourself, occupy the spaces. Then everything else is done. And of course, resources. Thank you.
Thank you so much. Thank you so much. And yes, please round of applause, please. I mean, my role was, of course, to facilitate and sum up, but I think this last round did sum up as well. So I don't have many things to say. I took so many notes and I will be able to share with the organizers. But perhaps just to emphasize 2-3 points. So the issue of building coalitions, and especially again with the organizations that have observer status, but also mainstream civil society organizations, right? So be able to pass the message across. And the second thing, be able to engage with other treaties, and not necessarily those that are responsible for disability, the African Disability Protocol. As we move to as we push for the ratification of the ADP, it's really important to pay attention, to the reservation, right? Make sure that we push for 100% ratification, full ratification reservation. Otherwise, we can undermine the potential of the convention, of the protocol. And the last thing really reinforce again the fact that OPDs have to be present. And I may want one thing here. The fact that we also have to pay attention to marginalized groups, right? So we know that within the disability movement, those who have more power, who have more structures, better established and so on, but also there are groups that out there that don't have structures. We need to make sure that everyone is represented. The diverse disability movement is very well represented in these places. So thank you so much. Thank you so much, University of Victoria, for the opportunity to facilitate this session. And I guess it's a lunchtime, right?